Well, thank you so much for joining us at Democracy and Our State Courts, Fighting Back After Citizens United. I'm Caroline Frederickson. I'm the president of the American Constitution Society, and I'm so glad to see such a full room today because this is an extraordinarily important topic and an absolutely phenomenal panel. As we gather here, I think we are, as I was not here to celebrate the 5th year anniversary of the Supreme Court's extraordinarily important, extremely misguided case, Citizens United. We are certainly here to mark it and mourn it and think about how to react to it and fix it. So there may have been, and there certainly was, disagreement before the case was decided about the legal arguments and the abstract principles about how we deal with money in a democratic system. But I don't think anybody at this point, 5 years later, would disagree about the impact and the unprecedented floods of money that have been pouring into elections of every kind, from the presidential election to local government, and probably if dog catchers get elected in those races as well. And so right now our public policy is for sale. Highest bidder wins. This really threatens our fundamental democratic principle that voters should decide election and not donors. And no segment of our democracy has been more imperiled by this money tsunami that has been triggered by Citizens United than our state courts. And, as I think we know, it's not a topic that's on the front page as much as the constant horse race you read about Mitt Romney and Paul Ryan and everybody in the next presidential, and is it going to be Hillary Clinton or Elizabeth Warren? Where is the conversation about what happens in our state courts? It just doesn't really rise, but this is an area of our government that is so important in people's lives. These state courts handle cases that really touch people in the most deep and existential way. Child custody cases, divorce, consumer disputes, criminal prosecutions. These courts decide cases that arise from state laws and constitutional provisions involving civil and human rights, environmental protections, criminal justice. Our state courts decide who can marry whom, who can vote, who can drink clean water and breathe clean air, and whether women get to choose how to make decisions about their own bodies or whether it's in someone else's purview, who the police can detain, search, and arrest, and who goes to jail and for how long. And make no mistake that the moneyed interest that were further empowered by Citizens United, they get this, and they are taking advantage of it. Right now, unprecedented streams of money are going into state court elections, and they are bending the arc of justice towards them, or I should say, they're buying the arc of justice. This trend really puts us all at risk in our system of justice. And as two empirical studies sponsored by ACS show, money is influencing outcomes in cases involving issues ranging from consumer and worker rights to environmental and criminal law. But we're not here simply to mourn that lost age of sleepy judicial elections when none of them were contested and no one paid any attention. But we really need to organize now. We need to figure out how to fight back so that we can reclaim those courts for justice and reclaim our democracy for the voters and not the donors. So we are really, really lucky today to have a group of speakers who are the leaders of this fight. They are so tremendously accomplished that we would be here for quite some time if I were to go through all of them. So I will not do that. But as I bring each of them into the conversation, I'll make a brief, wholly inadequate introduction, and then ask you to consult the biographies that you have in your materials that will give you all the dazzling background that you need to know about the many, many accomplishments of this wonderful panel. So we are going to try and go fairly quickly today. I know there will be a lot of questions. I see a lot of people with expertise in the audience. We want to have time for that at the end. So we're going to get started quickly. I do want to just remind everybody that we are recording this program for web streaming. I would ask everybody, particularly when you're asking a question, please wait for and use the microphone that are provided. So we are going to start with Bert Brandenburg. Bert has been the executive director of Justice at Stake for over a decade. And Justice at Stake, as many of you know, is one of the leading organizations advocating for fair and impartial courts. And I think, I'm going to ask the total softball for Bert because I think this will set up our conversation. But really, if you could succinctly and compellingly, and I know you can because you've done it, summarize the role state courts play in our democracy and the history of judicial elections in America, well, it's you. And so 3 minutes, Bert. All right. Sum it all.
Let me begin tweeting here. So good afternoon, everybody. Thank you, Carolyn. Thank you, ACS, Brennan Center, all the people who worked to bring this together. As Carolyn mentioned, Justice at Stake has the privilege of working on these issues full-time. We lead a national coalition of organizations working on fair and impartial courts. Our honorary chair is Sandra Day O'Connor, and in terms of setting the table with the two topics you described, why are courts so important, and how in the world did we end up in a situation where we elect something like 90% of our judges in the United States, I would start by saying that strong and effective courts are the superglue of a constitutional democracy. They uphold the Constitution. They protect our rights. The other branches are supposed to do this. This is a core mission for our courts. They're supposed to tend to this full time. Our court's mission is to be impartial, not political. Our courts are supposed to be the place where power is checked at the door and where everyone can get a fair shake. And as Carolyn said, since every important issue that we all care about comes through the courts, they matter to everyone, to consumers and workers who need a level playing field, to the accused whose very lives depend on equal justice, to businesses who need stable rules to create jobs, to an asthmatic child who needs clean air, and to every single person here today who knows that if you don't have fair courts, you can't have fair elections. And because courts are supposed to be fair and not political, the framers of our Constitution insulated the federal courts from political pressure. And in fact, in the Declaration of Independence, one of the colonists' chief complaints when they listed out their complaints against George III was that he had made judges, quote, dependent on his will alone, unquote. This goes back to our founding. So what about state courts, who handle 98% of all court cases in the United States? In the early days of the Republic, most states used variations of the federal system. But in the 19th century, in the earlier decades, the selection of judges was seen as having become kind of a corrupt little parlor game. It was the insiders. And it was making courts accountable to the insiders. And so Jacksonian populism launched a new paradigm, popular election of judges. And the goal was to make the courts stronger, actually, by insulating them from being accountable to the political bosses. And since then, every state, since the original 13, has adopted some version of judicial elections to select most, if not all, of their judges. But it didn't take long for the vacuum to get filled, for party bosses to make judicial elections tools of their patronage. Scandal and corruption followed. And so in the 20th century, in reaction to those problems, you had another new paradigm created, and that was merit selection of judges. And in that system, you have a nonpartisan selection committee that conducts rigorous interviews, that does rigorous vetting. Their goal is to pick a slate of high-quality candidates from which the governor can pick a judge. A couple dozen states have adopted merit selection to pick high court judges. So now, in the 239th year of our republic, judicial selection in the United States is a patchwork of these systems. They vary across states. They often vary by level within a given state. And thousands of state judges across the country face a paradox every day, which is that on the one hand, the Constitution calls upon our judges to be profiles in courage, to uphold our rights, even when that means not being popular. On the other hand, almost 90% of our state judges must stand for election. And as we will hear about in just a minute, those elections are being turned into tools of political pressure. That is why we are here today, to explore the most important democracy issue flying under the radar of the American political scene. It's whether our courts can be impartial and provide equal justice under law, or whether politics will pressure them to be accountable to partisans and special interests instead of the law and the Constitution. That is why Justice at Stake works with advocacy groups to lead a broad coalition to keep our courts fair and impartial. That's why we're so glad you're here today. Thank you, ACS, for putting this together.
All right. Well, thanks, Bert. I think that was a wonderfully brief but fulsome description of sort of where we are and how we got here. I'm now going to turn to Alicia Bannon, who is a counsel with the Brennan Center's Democracy program. Alicia has contributed extensively to the New Politics of Judicial Elections, which is a series of publications that has been put out by Justice at Stake and the Brennan Center that analyze how much money is flowing into judicial elections, from and to whom, and in what ways. So, Alicia, especially after what Bert has said about, we think of our system of justice as supposedly impartial and not political. We have that image of blind justice with her scales, but don't we all now sort of wonder if she's not actually peeking under her blindfold and reaching her hand out to see who's giving her money? Are we being too cynical, or what is the state of play with money in state judicial elections?
Well, the state of play is that, in the past 15 years, we've been seeing money flooding into judicial elections in states around the country. We saw the opening shots of this in the 90s. Someone you may have heard of, Karl Rove, was influential first in Texas and then in Alabama in campaigns to shift the ideological compositions of those courts. And you saw some big spending, $1 million races in those states, but it was a very rare occurrence. Starting in the 2000s, it became more and more common, spreading to states around the country, where we saw typically money from business interests pouring in on one side, money from plaintiff side trial lawyers, unions pouring in on the other side, essentially trying to shape who's sitting on courts and ultimately the decisions that courts are making. It's a trend that, as I said, started to pick up steam in the 2000s, but in recent years, especially post Citizens United, that trend has in many ways been exacerbated. What we've seen in the most recent years, most notably, has been a surge of outside spending, in so-called independent spending in judicial races. In the last presidential election cycle in 2011 to 2012. We saw record levels of outside spending by interest groups as well as political parties, and preliminary analysis of this most recent cycle suggests similar trends as well. And there's a few reasons why I think that's in particular quite troubling. First off, when you look at how that money gets spent, when you see rises in independent expenditures, that money is much more likely to be put towards attacks. So, for example, if you study television advertisements, they're much more likely to be negative when they're sponsored by independent groups as opposed to the candidates themselves. And that's something that played out. Even this most recent cycle in North Carolina, for example, you had a very negative attack on a judge. A decision she made was, distorted she was characterized as having sided with child molesters, for example. That's the tenor of what we see in a number of these judicial elections, particularly as outside money becomes more prominent. Another reason why I think this trend is particularly concerning is that, a lot of the rules around judicial elections haven't caught up to changes in how this money is being spent. So, for example, rules around disclosure, who's behind the spending in these judicial races. In many states, the rules for independent expenditures are quite weak in contrast to rules around disclosure for contributions to candidates directly. Similarly, rules around judicial recusal, when judges are required to step aside from cases when money has been spent to support their election, most states have very weak rules, if at all, any rules addressing independent spending in judicial elections. elections. And so while we see this flood of money by, groups that are trying to influence the decisions that courts are making, that are playing a tremendous role in shaping both the content of these elections and, I think create legitimate questions about, ingratiation between judges and these big pocketed spenders, you don't have rules that reflect these new dynamics as independent money is becoming so important.
Right. Well, thank you, Alicia. And you've already started us down the road of talking a little bit about how this plays out in specific issue areas. But I think it's really important for us to understand this isn't just an abstract kind of good government issue, as important as that is. This is actually about real decisions that are influenced by money that have real effect on people's lives. And so I think we're going to turn to Courtney Height right now, who's the director of the Democracy Program at the Sierra Club, to talk a little bit about that. How does this actually affect people? How does this affect you and me and our friends and family, that the judges who are supposed to sit impartially on cases affecting all sorts of important issues in our communities may be unduly influenced by money? Courtney, what is it that you and the Sierra Club really think is going on with state courts? Why do you think it's so important that they're fair and impartial? And particularly, can you talk a little bit about the ways that the courts have ruled in environmental protection cases?
I think for the Sierra Club, a lot of what we do, one of our big focuses right now is tackling the climate crisis, which is massive and large. Something, public opinion, science is behind us. But the problem is the fossil fuel industry, right? Like, they make money, they have power, they want to maintain it. And so they are finding more and more ways to influence decision making. And I think one of the biggest challenges for us is that, we mobilize people to weigh in on these processes. That's what the NAACP, SCAU, many issue-based organizations do, is we weigh in to move policy, move decision makers. And when we're not able to weigh in, we can't be successful. So we're at a point where we see the system as being rigged from it, our legislature, our Congress, a Senate that doesn't do anything, voting, the Supreme Court gutted the Voting Rights Act, so essentially taking millions of people out from actually weighing in that way. And then also in the courts, this is something that isn't new to us. The modern environmental movement started mostly by passing massive laws that we've then defended over the last 50 years, the Clean Air Act, Clean Water Act, NEPA, and that continues to be challenged, and it's moving down into state courts, which is where the federal government is given a lot of authority. And these are issues our folks really see the connection to, but in terms of the fair court element of it and making sure that the system itself is working is sort of a new concept, I think, for us, in the sense of we need to address that piece of it. I think, again, this is where, if we're going to defend clean air and clean water, the courts have really been the place that have upheld that. And now that we're seeing the Koch brothers investing more and more money in judicial elections, it's very clearly to drive the agenda that they are moving, which is more fossil fuels everywhere. And so a focus for us has really been on, if we're going to build the movement to actually address climate change, this is an inclusive movement that also has to include all of the people that are affected by these issues. And you see a lot in communities that have oil refineries, have coal plants, are also the very communities that are targeted by voter suppression and can't weigh in that way. So part of our engagement in these issues is making sure that we're lifting out the voices of those folks to be able to communicate, help them lift their own voice, not do it for them, and actually weigh in. So the court element is something that, for us, we see as critical to our long-term sustaining these goals. If we, move the administration to pass EPA health standards, but then, the D.C. Circuit Court overrules that, we don't make progress. So this is an area that we continue to work in.
Right. Well, thank you, Courtney. So immediately to my left is a dear friend and wonderful advocate for justice, Joanne Wallace, who's the president and CEO of the National Legal Aid and Defender Association. And Joanne has been, throughout her career, devoted to defending poor people who've been accused of crimes, and often unjustly. And, they are an unfortunate sort of roadkill in some ways of the money in politics that has come into the state judicial system. And I will just mention that ACS put out a report this fall called Skewed Justice, which shows that the independent expenditures that ran and that Alicia has mentioned that have grown so exponentially post Citizens United have used the frame of, oh, Justice so-and-so let a child molester out of prison, or using some case involving a crime as the way to go after a judge, even though the interest that might be represented by that money is actually coal or gas or banking or something else entirely. And I wanted to ask you, Joanne, how do you see this in your world? Is this getting worse? Is this something that you have you are thinking about in the criminal with the folks who do the critical work of defending people who've been accused of a crime? How are you adapting to this new post-Citizens United world?
Thank you, and good afternoon. So the bottom line for us is that in order for our court system to work effectively, people have to trust that it's fair, right? Once the court has ruled, people have to accept and abide by the final decisions of a court. And there's an entire body of research which really looks at procedural justice, which looks at whether defendants and other litigants perceive the justice system to be fair and the impact of that. And what's really striking about that research is that people's perception about the court and what they think about it is really more about how they felt they were managed, how they were treated, has a greater impact on their attitudes toward the system than actually the respective outcomes. So in other words, how I was treated matters more in many respects than whether I won my case or not. And that translates into, if I'm a juror, if I'm a witness, do I think that the court system, do I think it's worth investing the time? Am I going to show up? Is my time going to be worth it? And certainly if I'm accused of a crime and presumed innocent, do I think I'm going to get a fair shake? Which translates into, if I'm convicted and sent to prison, how will I behave in prison? That's, am I going to agree, maybe not necessarily like the sentence, but do I think that I was treated fairly? That affects how I am in prison or how I am on probation and parole and how I respond to verdicts. And this is true in civil and defender cases, civil and criminal cases. And historically, the public already has less faith in the criminal justice system than, in many of the other institutions. And indeed, public's faith in our institutions generally has been going down. Look at Congress, which I think plummeted to about, 7% at one point, 6%, okay. And so it's critical in terms of the court as an institution, because of course, if you distrust other institutions, that's where you go, number one. But also in the criminal justice arena, it is critical that people believe that everyone is being treated fairly. At the National Legal Aid and Defender Association, we often say that the quality of justice you receive shouldn't depend on the amount of money you have. And generally what I'm talking about when I say that is that you should have access to an attorney, whether it's in civil court or criminal court. You should have access to a lawyer, whether you can afford to pay for it or not. But the reality is that especially after Citizens United, that phrase can just as easily refer to this issue. People are not going to have confidence in the fairness of our judicial system if they believe that judges can be bought by the highest donor.
Yeah, thank you, Joanne. And there's one piece of our report that I neglected to mention, which is very tied to what Joanne has just said, which is it's not just the volume of ads, but actually when then the justices make decisions about cases, their decisions have changed post-Citizens United and become more anti-defendant. So the ads and the volume post-Citizens United have made them scared of the punishment they're going to get, the ads that are going to go after them if they do what they are constitutionally obligated to do, which is be fair. in a case in front of them. So I think, it's obviously of great importance in all of the issue areas, but it's so existential when you think about what we think is one of the most critical roles of our justice system, which is due process and fairness, and exactly what you're saying about the perceptions people have. Right now, we know that the perceptions of unfairness are actually backed by data, unfortunately. And speaking of perceptions and the reality of unfairness, we want to talk a little bit about voting. We all agree, I think, that our state courts should be a referee between partisan activities between the parties and how our elections come out. They should be administered fairly, just like our criminal justice system should be administered fairly. Unfortunately, the role of money in influencing state court judges has played a role here as well. So I'm going to now turn to Greg Moore, who is one of the leading defenders in this country of voting rights. He's a senior strategist at the Democracy Initiative and executive director of the NAACP's National Voter Fund. He's been coordinating activists to combat voter suppression and to support efforts to make it easier for Americans to register and participate in democracy. It shouldn't have to make an effort to do that. It seems like a natural thing. But in any case, Greg is doing such important work. Greg, historically, our state courts have played a really important role in voting. And post Shelby County, obviously, with the lack of Section 5 and the prophylactic of the Department of Justice, state courts have become so much more important. So what do you see going on in the state courts around voting?
Well, first of all, thanks for the opportunity to be here, and happy to join my colleague Courtney Height. We work arm in arm together at the Democracy Initiative to build some convergence between these issues. I was watching the reviews of the movie Selma and saw Joseph Califano's defense of President Johnson's role in passing the Voting Rights Act, which you just referenced. And he made an interesting comment, I never heard it, that on the way back from delivering his remarks, or after the bill signing, I guess, that he immediately got the Justice Department on the line to start filing lawsuits under the new provisions. And so ever since that moment, I think the marriage between voting rights and our courts have been really playing a big role. Now, a lot of times we have seen it for the better and we've seen it for the worse. Certainly there's been some good ways that we viewed federal courts as protecting our rights, but we've also seen where state courts have emerged and stood with us when the battle was run. I can only bring up one case, our Bush v. Gore decision, which basically saw a state court say, hey, count all the votes so we can figure out who we should award our electoral votes to, and the federal government saying don't count all the votes, or I'm sorry, the U.S. Supreme Court saying don't count all the votes because we don't want to set a precedent, but we don't want to basically ensure that all the votes are counted because it might lead to a different result than maybe what some people in that court thought should happen. I won't go any more into that, but maybe if you went through that experience, you can't forget about it when this topic comes up. When Citizens United was announced, we had just we have been in a battle of this Voting Rights Act being chipped away at little by little with enforcement, first of all, but actually with the issue of whether or not all the protections that people have had in these states that were covered deserve the continued scrutiny of the federal courts. And we had just passed in 2006 the reauthorization of the Voting Rights Act. So when Shelby came down, and then McClutchin and some of these other decisions, it now became clear that the federal court, that the U.S. Supreme Court could not be relied on as an ally. Therefore, it seems to me that the state courts and the work that the state courts are doing and the advocacy work that's being done at the level to protect voting rights really need to look more to the states and the state courts as a place where we have to have these battles won. There was an article that I was asked to read, Joshua Douglas's article about the role of state courts and voting rights. And as far as I got into the article, I could see how there was a lot more focus on, in the media, by what's happening at the federal court level, not so much what's happening at the state level. I'm out of time already, but there are two things that were said today that I thought was interesting, and one was said by you about bending the arc of justice is now turned to buying the arc of justice. That was an important line because that increasingly becomes a part of the narrative. One final point, I'd be glad to get into the Q&A part. Down ballot is where a lot of these court elections are decided. They're called down ballot because people vote for president and senate and governor. And if you're the average voter who's been in line for 2 hours, you're not going to stay in another 10 minutes to get to those down ballot. Even if it's the Supreme Court, they're way under the fold of your ballot. Sometimes you got to turn the page 2 or 3 times. So the lack of participation of people voting in those judicial races does impact that as much as this money issue impacts it. We've been able to fight and draw convergence between the money in politics and how it affects elected officials. But if now, because of Citizens United, that fight has to be carried full scale into the judicial realm, then now we're fighting policy on 2 fronts, and one has a role born and one doesn't. So it's easy to fight the one when the guys are in there fighting each other in Congress, but when that battle has been taken to the people who are wearing robes, it becomes a lot more challenging for activists to take on this battle all the way. So we need to work out strategies that we can use to make that a better and more transparent battle.
Greg, thank you very much. That's I think there's a challenge to all of us because it is obviously the more battles there are and the more places, the more resources it takes, and that's easier for those with the deep pockets. But you mentioned Bush v. Gore. We often think of one of the other big cases of the Supreme Court is Roe v. Wade, but people in the world of reproductive rights know that similar to voting rights, it's not all Bush v. Gore or Shelby County, and it's not all Roe v. Wade or Casey, but there are so much going on at the state court level that has to do with chipping away at women's rights on a daily basis in many creative ways. We're very, very happy to have with us today Christine Kippens, who is a federal policy counsel at the Center for Reproductive Rights. She has an important resume because it includes that she was a colleague of ours at the American Constitution Society, much beloved, and we are very happy to have her with us today. So, Christine, at the Center, there's a lot of federal litigation, and clearly, as the cases I mentioned, there's a fairly large, robust body of cases that were more expansively protecting women's rights, are now less expansively protecting women's rights. But can you explain a little bit better? What is the community seeing in the state courts? What are you battling there? What's happening?
Well, thank you, Caroline. It's true that most of what people think of with when it comes to reproductive rights in the courts, they think of all the federal cases. They think of Roe, they think of Griswold. But there's a lot going on at the state level right now that makes it incredibly critical that we focus on this issue that these 3 great organizations have brought us here to discuss. There have been several types of restrictions brought at the state level that has been limiting women's reproductive rights, particularly when it comes to abortion. There have been abortion bans, laws interfering with the clinician-patient relationship, trap laws that cut off affordability to critical reproductive health services. And these laws have been very effective at the state level in closing clinics. And when this happens, it leads to a threat to access to contraception and maternal health, because abortion clinics provide more services than just abortion care. There's family planning, contraception, cancer screenings, just basic health care. And we're at a time where there's a heightened threat to the availability of legal abortion services. So in the past 4 years, 231 of these types of restrictions have been passed, which is actually more than the entire previous decade combined. it's quite a statistic. And the number of abortion providers has steadily fallen since 1982. About 89% of all U.S. counties lack an abortion clinic. And the number of providers will continue to fall unless courts enjoin these new restrictions, as was illustrated in Texas, where the number of clinics shrank by about half after the Fifth Circuit allowed an admitting privileges law to go into effect. But women also increasingly depend upon state courts not only to respect their rights to terminate pregnancies, but also to protect their liberty, equality, and dignity during pregnancy. Broad definitions of personhood have been used to punish or control women because they've had an abortion, experienced a miscarriage or stillbirth, or engaged in a behavior a prosecutor or physician deemed harmful to fetal development. And they also threaten women's access to the most effective and personally appropriate methods of contraception. Additionally, state courts provide an additional line of defense to the federal courts. Ultimately, access to constitutionally protected reproductive rights should be protected at the federal level and not vary by state or access depend on one zip code. But however, there's been a long-term effort by anti-choice proponents to undermine and eliminate some of the protections of Roe, and they have met with some success in the state courts. 40 years ago, Roe was not a partisan issue. The opinion of the 7-justice majority included 4 justices appointed by Republican presidents. But today, the Roberts Court is sharply divided, with 5 Republican appointees ruling in favor of restrictions on individual rights, and in multiple cases, the 4 Democratic-appointed justices in dissent. And finally, the importance of state courts for protection of reproductive rights makes the issue of judicial selection in those courts important for advocates. Coinciding with the increased need for state court protection, opponents of Roe have ramped up efforts to populate state courts with like-minded judges. The Republican State Leadership Committee launched a state-focused judicial fairness initiative, which at the federal level calls for the selection of judges who oppose Roe, and state anti-abortion organizations regularly target particular judges and nominees. And at the state level, they oppose entire systems of judicial selection, viewed as interfering with the ability to select judges based on prospective judges' positions on reproductive rights. And so to conclude quickly, I'll just say, to protect and realize reproductive justice, all persons, regardless of personal identity, race, economic status, geography, must be able to access and freely choose reproductive health care, which in turn depends on a fair and impartial judiciary.
Thank you, Christine. That was a great summary. And I was just thinking as you were talking how I think that the people tend to know a little bit more about the fact that sometimes you have a big corporate interest like Massey Coal that gets really involved in a state judicial election because there is a financial issue at stake. And they use criminal justice as the frame in that case, too. In the Massey Coal case, they use child molester attack ad. But that the social issues, as we call them, are often also used. And there was a very well-known situation in Iowa where the issue was about gay marriage, and a lot of money came in from out of state to defeat a couple of their justices who had believed that equal marriage was a right. And so I think this is obviously an issue that's becoming more and more relevant in more and more areas. So before I turn back to the panelists for some more comments, I did want to mention the papers that Greg alluded to, the one that he had read. But I want to just mention this is this wonderful new resource that the Piper Foundation has made available. And thanks to their generosity and their strategic vision, 4 brilliant scholars have prepared in-depth analyses of the 4 issues that we've discussed today. And they are Protecting Reproductive Rights in the State Courts by Don Johnson of Indiana University Law School. Has an appendix called Anti-Abortion Efforts to Stack the State Courts, and Don is a ACS board member. We're very proud of her. State judicial elections and environmental law, case studies of Montana, North Carolina, Washington, and Wisconsin by John Echevarria of Vermont Law School. State judges and the right to vote. This is the paper that Greg had mentioned by Josh Douglas of the University of Kentucky College of Law. And, as I mentioned before, Skewed Justice by Dr. Joanna Shepard and Dr. Michael S. Kang, who are professors of law at Emory Law School. And as I mentioned, Skewed Justice looks at some of the trends that Joanne had talked about, and ACS was very proud to have published and promoted that report. And all of those are available for you to download at the ACS website, which is acslaw.org/state-courts-matter. And there are flyers outside, so you don't have to remember all of that right now. But those papers are really, really helpful, and I hope you will take a look at them. So we're going to have a chance to have one more go-round. I know that people are eager to ask questions, but I want to give all the panelists, before we go to more questions, an opportunity to comment a little bit more broadly. And I've already have Bert, who has something that he wanted to comment on Greg's discussion about voting. But I did want to also ask all of you a little bit about how do you see the money? There's different ways the money comes into the system. Do you see it affecting the system differently? Are they equally bad? Direct contributions, independent expenditures, and then I think talking a little bit about what Alicia had brought up, which is how do you can control some of that through, what are some of the solutions? What are there disclosure rules? Can you give the audience a little bit of your thinking about where do we go from here? What should we be asking the people in this room and elsewhere who may be watching this? How do we clean this up? So let me start with you, Bert. You're Mr. Clean It Up, so help us out.
My mother used to call me that. I'd actually love to be part of the solutions discussion. Before I get to that, maybe in the round robin, I actually wanted to add a little bit more, some specifics to add some more meat to the bones of what Greg was saying, because this is hugely important. It's staring us in the face in terms of what's been going on with voting rights in the courts. And as Greg said, when it comes to voting rights, what you pass is what you start with. It then goes to the courts. And since 2010, our state legislatures have been very busy. That was a watershed election. We've seen 22 states since adopt rules restricting voting rights. The good news is we've seen 11 states actually improve them. In both cases, that's going to be headed for court. So this is huge in terms of what state courts do. And just this past year, we saw state Supreme Courts in Arkansas and Iowa, popularly elected, strike down restrictions on voting. There's a challenge pending in North Carolina, which is becoming one of the poster child case states in terms of the money. In Tennessee, interesting, this past year, they saw their records smashed, $1.5 million poured into unseat 3 justices. One of the subplots there was that uniquely amongst the states, in Tennessee, the Supreme Court actually chooses the Attorney General. Interesting quirk of their history. And in fact, a couple of years ago, the Tennessee Attorney General had found in 2011 that their new voter ID law was unconstitutional. So there was some payback coming around. And then finally, as another interesting example, Christine mentioned the Republican State Leadership Committee and their Judicial Fairness Initiative. They dumped $300,000 this past year into a Missouri Circuit Court race. This is very unusual. We track mostly state Supreme Court races. This is where the big money is for the obvious reasons. We don't see this very often at all, and they work to try to unseat a judge named Patricia Joyce with the Cole County 19th Judicial Circuit in Jefferson City, Missouri. Well, why would that be? As it happens, that court has initial power over cases coming out of the Missouri legislature because they're in Cole County in Jefferson City. And in fact, Judge Joyce, 2 years ago, had struck down a voter ID ballot initiative. So the payback can come in a lot of different directions. The courts are completely intertwined with voting rights, and increasingly this is becoming a state court issue.
Okay, so can I get you on the hook for some solutions since you're
You bet.
you're there? Because you want to leave us all depressed.
Yeah, my mother said something about that too. But I'll start with one. There are plenty of them, and lots of people here can talk about them. I guess what I would say is that the issue is getting more and more fundamental. So the the issue of reform has to be looked at in a fundamental way. And the system I mentioned a few minutes ago, merit selection of judges, has to date not been waterproof. No system is or ever will be, but has largely been the most effective in insulating judges from the scrum of going out and becoming professional fundraisers and feeling the pressure from the groups when they run the ads. And as I mentioned, that's a system whereby you have a screening commission. It has to be nonpartisan. It has to be diverse. It has to be transparent. It has to be a good commission. And they haven't always been good, but they're getting better. And then the idea is that they produce a slate of qualified nominees, any of whom would be a good judge. The governor gets to pick one. The reports from these commissions are actually quite good. There are a number of states where the commissioners report that people actually manage to come in and check their politics at the door. And they just take the job very seriously. It has a lot to do with the culture you set in the state. But it's one of the more promising reforms. It requires you to typically change a state's constitution. So not the easiest thing in the world to do, but it's reaching a point where it's really one of the most promising reforms amongst the menu. But there are others as well.
Mm-hmm. Right. Well, why don't I ask my two friends who were active with the Democracy Initiative, which I think is a wonderful initiative that has been born of the efforts of Sierra, the Sierra Club, of the NAACP, the Communications Workers of America, and Greenpeace. Thank you.
And Common Cause.
And Common Cause. So it's just terrific to try and shine a light on the importance of democracy as the fundamental piece underlying all these critical issues that we all may work on separately in our lives and bringing together. And I think that's been terrific, and hopefully will help us get towards a solution more generally. What is the Democracy Initiative, or your groups individually? What are the sort of avenues that you are pursuing in terms of responding to the impact of money in state judicial elections?
Why don't you go first and I'll confirm.
Well, I mean, I think, as sort of mentioned before, I mean, these are issues that we're all facing, right? Like organizations that work on any issue, whether it's women's access to health care, a living wage, environment, civil rights, those little things. Making sure the system actually works is critical, and I think that's something that many of our organizations have started to really wrap our heads around in the last 3 years, which is why we started the Democracy Initiative, was realizing we have to go after these systemic problems if we're going to actually make the long-term change on our issues. But that these systemic problems are quite deep and buried within the system. And so, how we're looking at this is there are a broad swath of policy changes that will need to happen. It's like climate change. There's not one way to fix it. But to get to that point, we actually most urgently need to build a movement, right? People need to be calling for and demanding change. And I think one of our biggest challenges right now is that most Americans, there's probably a more recent poll, but the one I like to quote is that 96% of Americans believe there's too much money impacting politics, but 91% don't believe there's anything we can do about it. So the first thing we have to do is show people that we can change this, that it actually, this is our government, this is we own this. And so we have to show the solutions, and that's part of why we've all come together along with 50 other national organizations to start working on these issues, is that we have to build power together. We have to win victories, and then we have to actually move some of these policy solutions that also impact how judges are selected and making sure our courts are fair, to making sure money that's coming in the system is not just coming from 1,000 billionaires that are not America. And so that's, I think, one of the core issues we're working on.
Yeah, and again, we're trying to say broadly voting rights is a priority of the Democracy Initiative, but in reality, and for a lot of people in this room, there's a lot that goes with that. The Voting Rights Act set a floor for what we can and can't do in a state to suppress votes. Then we got involved in other reforms that I was involved in earlier in my life. The National Voter Registration Act, which set one national standard for voter registration. The Help America Vote Act, which sets standards for how you count votes and provisional ballots. And then what you've seen is that these floors have been set at the federal level, but now you have, on our part, attempts to raise the ante, that these are the floors, not the ceilings of what we have in our rights. So people are pushing same-day registration. People are pushing easier early vote provisions. And then all those things did start happening between 2002 2006. The pushback has been these regressive laws that happen surprisingly, after 2011, which is after the House and the Senate had this big wave of Republican takeovers of many state legislators, and that's where a lot of this stuff started in the modern times. And the fight in the Democracy Initiative has been to try to build a stronger base of support to battle this effort that's being done collectively across the country on the other side to basically restrict the right. We're trying to push back collectively with our progressive allies and friends in labor and environment and really everyday people who believe in democracy to push to say, no, we want to restore this to the battle to get to the ceiling. We're not trying to race to the bottom of our democracy. We're not trying to restrict people's rights. So to the degree we can find convergence with what Justice at Stake and many of your organizations are doing, we're trying to say, hey, we have a battle going on here, but the battle of money and politics is one thing, but now it's seeping deeper into the courts. We have to have a two-pronged strategy to make sure people can connect these two. And I'm just now going through that process myself as a voting rights activist to see how these two things intersect. And the Democracy Initiative is a good place to have that conversation.
Right. Thank you. I'm going to ask you, Joanne, because I think obviously of all the issues, when you really do think about someone perhaps being locked up unfairly or having a much longer sentence than they deserve, being charged with a crime that they're innocent of, there's critical and existential and some of the most fundamental rights that we value in a society is having a fair criminal justice system. How have you seen the sort of the increase in partisanship or the role that money has played to influence judges affect those criminal defense issues that you work on every day?
So I want to answer that question, but I also want to answer your earlier question about solutions.
Oh, good. Okay.
So number one, first of all, this issue has been going on for a long time. It's not new. It's become exacerbated, right? I mean, this is not a new issue. It's just getting worse. And in that regard, to talk a little bit about specifically, how does this play out? So in the criminal context, imagine this, right? Most individuals in this country who can't afford an attorney, and that's most people who are charged with a crime, some of them get a public defender, but many and most of them get a court-appointed counsel appointed by the court, appointed by the judges. And so think about this scenario that you are, let's say, you're charged with a crime, presumed innocent, and maybe even actually innocent, and you get a court-appointed lawyer, many of whom don't really have adequate resources to do the job that needs to be done in order to competently represent you. Maybe they haven't had training, they're just not qualified for the job, but they represent you nonetheless, and you get convicted. And you think, justifiably so, that your lawyer has done a really poor job. And then imagine how you're going to feel if you later learn that that lawyer was one of the biggest contributors to the judge's campaign that your case was in front of. Are you going to question whether that attorney was appointed because they're qualified to represent you or qualified for that case, or are you going to think something else? And regardless of whether it actually influenced the appointment or how the judges rule or treats the lawyer, should someone in that position who is facing, the loss of their liberty or possibly death even have to ask that question? Should anyone ask that question? And if it's not a criminal case, even in a civil case, if you're facing the loss of your home, your family is going to be, homeless, and you're dealing with a landlord that has money and interest in the real estate, how are you going to feel if you find out that indeed, the judge who's on the case has, they're one of the biggest contributors to their campaign? The bottom line is this, two things, and that gets me into solutions, which is number one, the laws, we really have to have strong disclosure and recusal laws across the country. And if you are familiar with a report done recently by the Center on American Progress, the fact of the matter is that almost every state would flunk, if you look critically at the laws that are on the books. Do they adequately address the issue? I think 5 states actually did not completely fail, and only with a C, a grade of C. So that doesn't say a lot. Bottom line is that information, judges minimally should be required to disclose, if they know of, if there's any potential conflict, they should be able to disclose, where their campaign money came from. And laws should be very strong that is a basis for recusal. Because think about it. The situation is hard enough. The hypothetical that I just gave you, what is that individual? As it is, he now has to go against his lawyer as well as the judge in order to, deal with what might have been an unfair trial. So that's really important. But secondly, the bottom line is, just like attorneys should be appointed to cases because they're qualified to do the job, that is the same for judges. They should be appointed to the bench because they're qualified to do the job.
Thank you. Put it very directly. So Christine, another existential area, women's lives in the balance. What, from the center and generally in the reproductive rights communities, what are you think are the most important avenues for us to pursue to ensure that those courts are fair when they decide those cases?
Well, I think definitely programs like this helps, where we're educating the public on the fact that this is such an important underground issue that most people are just not thinking about, and that there is hope for reform, that people develop various methods, various ways of changing the system. Unfortunately, the center is a litigating organization, so we're before judges, every week. So we are not that involved in the reform process because it might be a little unseemly for us. But we do encourage programs like this and participate in programs like this because we think it's so important that people know just how much the courts do matter on these issues. It's not just about the legislators at the state house passing these restrictions. At the end of the day, it always ends up in the courts, in the state courts, in the federal courts. So as an advocate, I definitely ask all of those at the table here to continue the work that they're doing and to keep elevating the issue.
Great. Well, let me turn, lastly, before we open for questions, to Alicia, because Brennan has done so much in this area. Can you give a little bit more background on what you see are the major reforms that everybody can take away on and start working on immediately after they leave today?
Sure. Well, I think a number of them have already been mentioned by other panelists. As Bert mentioned, in his opening remarks, I think we often forget that judicial elections were introduced as a reform measure, and unfortunately, what we've been seeing is as money has become such an important part of how these races are won, the accountability mechanism has become distorted, and so I think a lot of the reform measures should be focused on readjusting that accountability mechanism. One reform that hasn't been mentioned yet is public finance of judicial elections. That's, I think, it's something that, unfortunately is a reform effort that has, been rolled back in some states recently. Right now there are 2 states, New Mexico and West Virginia, that offer public financing for judicial elections. 2 other states, Wisconsin and North Carolina, recently eliminated public financing programs. I think North Carolina's is particularly illustrative. It was in place for a decade. It was very successful, utilized quite widely by the appellate and Supreme Court judicial candidates, and I think was generally seen as a very effective tool to allow candidates to run competitive races without needing to rely heavily on special interest dollars, and not have to, as judges, put themselves in an uncomfortable role as fundraisers. This was the first year, 2014 was the the first time in a decade that public financing wasn't an option for judicial candidates. Not surprisingly, among other things, we saw record levels of fundraising within North Carolina, and we saw a number of candidates and judges be very vocal about the fact that they were not comfortable having been put in the position of essentially having to be a politician in robes, that they would much rather spend their time deciding cases, doing research, playing their role as a judge, and instead they had to spend significant portions of their days dialing for dollars. And so I think public financing is one important reform that could make a big difference in mitigating the influence of special interest dollars on judicial elections. A few other reforms. Certainly strengthening recusal rules is, I think, a vital reform, particularly, as I said, the way money is being spent in judicial races has changed over time, and outside spending has become a much bigger part of the composition of money in those races. And rules just have not kept up with that. So most states don't provide any guidance whatsoever as to when judges have to step aside from cases in the face of independent spending. And that's something that's a clear fix that state courts and state legislatures could do. I think strengthening disclosure is another aspect. And then, as Bert alluded to, I think there's also a larger question of, as I said, judicial elections were introduced as a reform measure, but as money is becoming an important role, and as the Supreme Court has chipped away many of the tools that we've used in the past to regulate judicial elections, I think there's real questions about their, continued viability even with some of these other safeguards. And one project that we're doing at the Brennan Center is looking more deeply at different options for reforming judicial selection practices. And just the very last thing I'll say, because I know people are eager for questions, is one of the biggest challenges with the money in judicial elections is the fact that these are such low information races. So it doesn't take a lot of money to quote unquote buy a seat on a Supreme Court, because oftentimes people have no idea who these people are. And so, if somebody has money to put out a few attack ads, that may be the only thing that people know about the candidates up for office. And so I think also public education efforts, voter guides, efforts like that are also vitally important so that voters have more information, and that hopefully that can dilute some of the influence that this money has on the races that we're seeing.
Right. Well, thank you, Alicia. And I don't know how many people here live in Montgomery County, Maryland, but you might have been confronted when you went to the polls with the startling experience of having a retention election all of a sudden for 3 judgeships have 4 candidates. It's very, normally when people don't pay attention, in part when there are retention elections, because you have 3 people and 3 seats, and it's just you check off yes or no, and there's no competition between candidates. And in this case, all of a sudden, we're presented with 4. And it's an example of an effort to change even the systems that are theoretically in this retention mode. And I have to say, there was so little information for anybody who bothered to do research to actually figure out who these people were. And how do you pick, unless you go back and find out who the original 3 were, you don't know who the competitor is. Anyway, I think it's something to think about, how even we in the legal community pay very little attention to these races and to the significance. And as they get distorted and changed over time and become more competitive elections, we're not paying that much more attention. So I think this panel has been really terrific in raising quite a number of dangers of the role of money in state elections, state judicial elections, but also some of the possible remedies. But I hope we have such a great group in here, a lot of people who know quite a bit about elections, about courts, about judges. And so I hope we have some good questions for this set of luminaries here with me. Over here. And please wait for the microphone.
This is Carrie Byron with IPS. I don't want to take up too much of this time because we can all look at the paper. I assume, Carolyn, you mentioned earlier initial findings about the impact that Citizens United may have had on voting records. I assume that's this skewed justice report?
Yes.
Can you just briefly talk a little bit about some of
Sure.
the most important findings that
I'd
you
be happy to.
and any other research in this direction that you know is going on right now?
Absolutely. Skewed justice is tremendously illuminating and very, very depressing at the same time. And basically what it shows is that post-Citizens United, most of the states had in judicial elections a ban on independent expenditures. So you couldn't run, outside groups weren't running ads for and against candidates for the Supreme Court of the state. After Citizens United, those were invalidated, and all of a sudden there was, call it a tsunami again, a huge influx of money from various special interests that ran ads to attack or to support, but usually to attack someone who, and it was just a proxy for the other issue. So the attack is usually, again, criminal justice issue. So-and-so had let a child molester out of jail, and that person is now working in a West Virginia school. That was actually in the Massey Cole case. That was Don Blankenship's foundation was set up to run these ads and get rid of this justice who was going to allow a case against him to move forward with big damages. But so the volume, it's both the volume went way up, but then you can actually track the impact, and this is why it's so depressing, that you see that looking at holding all of the other factors equal, if you look at the post-Citizens United world, you'd see that the actual way that the judges rule on cases involving these were major crimes changed and became more anti-defendant. And so that is very, very important because, again, I think, it's one of the things that we think our justice system should do, which is be fair. And all of a sudden you see judges are saying, well, okay, look, I'm mostly going to be good on all these other cases involving the environment, or maybe I'll be good on women's rights, but I'm going to be worried about, when I have someone accused of a murder in front of me, because I know there's an attack ad that's going to come out of that, even though it's the coal industry that wants to go after me. And so they're going to take that off the table. So I think, it's very, very discouraging about what role money can play. And again, this is just, there's kind of a casualty. The rights of criminal defendants are a casualty of other interests typically, but over 50% of the ads have been in the criminal justice frame. I'd say the other report that we did along these lines is called Justice at Risk, which looks at direct contributions from business interests and shows that there is a certain dollar value that affects how Supreme Court justices rule on the business cases in front of them. And in that case, we actually found, or not me, I'm not a statistician, I don't really know how the research was done by scholars who do this for a living. But they showed that actually the democratically aligned or democratic justices were the ones who were more likely to be affected. That is, conservative or Republican aligned were more likely to rule with business interests anyway. But once the dollar volume for the democratically aligned got to a certain level, that was the tipping point. So again, I think for progressives, that's something to think about. That money plays a role, both the independent expenditures in terms of how the rule on the collateral damage of criminal defendants' rights, but also the direct expenditures, and how theoretically progressive judges might change their votes on a case involving environmental degradation or cleanup requirements or something that's going to affect a business interest. So I'm sorry if that wasn't too long, but they're both really important reports, and you can find them both on our website. Bert, you wanted to?
I could just add just a touch here because in Citizens United in the dissent, Justice Stevens essentially predicted that the courts were going to come in the crosshairs. He pointed this out and said it's going to be open season on them, and that's what's happening. And judicial elections, if you think about it, I think they're uniquely fragile in terms of what this pressure could do. Most of our politicians, for better and worse, I think, come through the process somewhat steeled and know that every time they do something that some people are going to yell and some people like it and some people write checks one way or the other. And it's got to the point where there's so much of it is having an effect on the system. But our judges typically don't come up through this type of system. They're not as used to when someone is outraged about a decision that they're going to come after them. So there's the risk that they'll take that pressure more seriously, and the data is beginning to suggest that in some cases perhaps they are. But the other thing that this does, and we're hearing this, is that it deters good people from wanting to become judges in the first place. Probably everybody in this room knows people who'd be a terrific judge, and think about how many of them would be willing to put up with this. And we're hearing this, and it has a disproportionate impact on communities of color as well. The flip side risk is that are we creating a system that's more likely to attract people to the bench who just see it as another stepping stone in a political career, because it's politics, and that's what they do.
Very good point. Well, we have a lot of questions. So when we go back here, see a woman in the green, or
Pardon me.
Hi, Laurie Sherman with Transparency International USA. On the solution side, I'm wondering, since I don't think you're going to do very well in many of the Republican-controlled state legislatures, whether there is a possibility through either the ABA or through judicial associations. I know there's a federal judicial association. I assume there's state judicial. Whether there's codes of conduct that you could try, or whether we, I should say, could try and introduce, get subscription to, or other non-legislative ways, which would be a possible way forward.
Alicia, do you want to take that?
Sure. Well, on judicial recusal in particular, I think that is a very promising avenue. Those rules, well, it varies state by state. In the majority of states, judicial recusal is governed by codes of conduct that are adopted by the courts in each state. So it's doesn't require going through the legislature. And so, particularly in states where you have hostile legislative environments, it is, I think, a very promising avenue. With respect to using the ABA as a mechanism for proposing model rules, that's a process. There's been a attempt to have the ABA kind of update its model rules to be responsive to, among other things, some of the changes we've been seeing and how money is being spent in these races and just the heightened politicization of many judicial elections. It's a process that has, at this point, there's not much movement. Most recently in August, the ABA issued a resolution essentially calling on states to look at their recusal rules and update them in light of, both to have stronger procedural protections, because among other things, not only do these rules not give a lot of guidance about the role of money, oftentimes you have procedural issues like judges deciding their own recusal motions without, any kind of meaningful opportunity for appeal, and, other issues just with judges being, judges of their own cases in ways that raise, concerns, as well as calling on states to look at the rise of independent expenditures and institute rules that are responsive to that. So I think there's been kind of a call to action at the state level. Within the ABA level, it's a conversation that is ongoing, but it has been very challenging within the ABA to get consensus around model rules for state adoption.
Up here?
I'm Abigail Woodward. I used to do fundraising in North Carolina, so I'm sad about North Carolina. I think that going back to more fundamental reforms that would pay off big would be nonpartisan redistricting committees. I just think that once you have a more level playing field, and now's the time to do it, because 2020 is going to be here before you know it.
Does anybody wants to comment, or should we go to another question?
I agree.
Okay. Good. Right up here.
Hello, my name is Morgan Ramsey. I'm actually an intern at the Brennan Center, but I'm also a college student at Duke University in North Carolina. Yes. Thank you. And I was actually wondering, this might be more directed to Mr. Moore, but in terms of the voting rights and getting people out to vote, I know my sorority and a lot of organizations on campus were extremely passionate about this and getting college people out to vote. But it still seems, I don't know the exact breakdown, but it just didn't really, the college vote really doesn't seem like it was there. So I didn't know if you had any suggestions as to what we could do as college students and how we could, because it seemed like we had a lot of a lot of information, education, and forums that had to do with voting rights, and it still didn't seem like people wanted to vote. So I didn't know if you had any suggestions as to how we could incentivize other college students to get out to vote.
Well, I do. A lot of what, first of all, I would take advantage of this passion that's out here right now among young people who are starting to look at the criminal justice system in a different way. Everybody knows it's stacked against African Americans, people of color, low-income people, people without education or money to have good representation. So they're seeing that the dots that are not connected is how any of the stuff we're talking about has any impact on that. The big fight in Ferguson was over the grand jury, and a lot of people don't connect the grand juries are made up of registered voters. And if you're not a registered voter, it's less likely that your grand jury will be representative of the people in that community. So if you have a disparate voter registration law and there's restrictions on people voting and restrictions on registration processes and restrictions on voter registration drives, it makes it a lot harder for that jury pool to be representative. So that's one thing I would do. I would tie it to what's being discussed out here. The other thing is just that recognize that these down ballot questions we talked about, so that a student can say, well, this is a pretty red state. It doesn't matter. My one vote doesn't matter. Well, sometimes it matters if you're talking about a state legislative race in these college towns where there are people who are representing what would be a more progressive district, but because the student turnout is so low, it creates these artificially unrepresentative districts. So I support redistricting reform. I'm sorry for that short answer. It's just so true. But if students and young people particularly did a better job of empowering their communities through their own voter registration and actual turnout, we're hurt by the same thing as everybody else. We want to just vote for president. We want to just vote for senator or governor, but we don't pay attention to the circuit court judge, and we don't pay attention to the state rep, state house, and we ended up paying for it as a result. So I would just have them focus on how their vote can make a difference and run for office themselves.
The back. Evan.
Hi, Layla Levy. I'm on the board of the Hispanic Bar Association of DC. And my question is about the quality, expertise, and impartiality of the judges when they do get elected. I know this was alluded to earlier, but for my organization and our affiliate, the Hispanic National Bar Association, we're always concerned about access to the courts for limited English proficient persons, concerned about vulnerable low-wage workers in everything from landlord-tenant court and the criminal context as well. And I'm just wondering what can be done to sort of eliminate an ignorance and bias among the judges that do get elected about these marginalized communities. And if I can put a plug for all of the bar associations all over the country that I know we work on this issue at a local level and a federal level. Thank you.
Well, I'm going to turn to Bert to start with. Anyone else can jump in at that point.
Sure. So a couple thoughts. This is a pretty huge question. There are efforts, and there are other people here who may know a lot more about them, to take the whole field of implicit bias training and other similar trainings and connect it into the judiciary so that the courts and the court staff, by the way, get the benefit of this kind of training and hopefully be better at responding to the type of issues that you're describing. I would say also part of the solution is to get a more diverse bench in the first place. And as we talk about all of these reforms, we should always be thinking about diversity as a lens through which we see this. The bench is not particularly diverse, certainly lags far behind the diversity of our country. And I'll put, and we know from psychological research that diverse groups arrive generally at better decisions than non-diverse groups. We know when we talk about the issues we're talking about today that we really need more diverse benches to be addressing them. I'll put in a little bit of a plug for a publication that ACS and Justice at Stake did in conjunction with all the national bars of color a couple of years ago, which we're still using, which is called The Path to the Bench. And it's a fairly small, easy to read, news you can use document, sort of pamphlet style, though it's a good 20, 30 pages. And it's very nuts and bolts description of things that you can use if you're earlier in your career and you're thinking about maybe becoming a judge and just all the things to know. And there's a lot of nuts and bolt things like those. And in addition to being a good publication in its own right, it can be a sort of springboard for events, and ACS has done many of these, and we've done some as well, where you bring in somebody perhaps from a community of color who's actually made it to the bench. They can tell their story, mentorships can be set up, and really just give people the tools they need to think about this. Because what we tell people early in their legal careers is that if you're thinking about becoming a judge someday, number one, that's great. Number two, you may not realize this, but regardless of your system, the race is actually already on. There are people who are in the club or have somebody with their arm around their shoulder, and here's the things that they know that you could know to help you get ahead. And we've run programs in 3 different states to promote this. So I guess I would say one of the solution sets here for a lot of people perhaps in the room and watching on the web is become a judge.
Yes. Absolutely. Absolutely. And if anyone needs copies of or would like to look at the How to Become a Judge, the Path to the Bench brochure that we put together, please let us know, and we can make sure you have that. Joanne.
Just one other comment. I agree with everything that Bert said, but he spoke earlier about merit selection processes and how that happens. Well, that type of process allows for making sure that the people who are doing the selection care about these issues and themselves represent the diversity of the legal community. And so I think that that's another one of the benefits of having really solid merit selection processes.
I saw there were a bunch more hands up, but why don't we, in the back, and then we'll take these two, and we'll see if there's time for any more.
I'll make it very short. I'm Mark Gruenberg. I'm with Press Associates Union News Service, but this is not a labor-oriented question. Ms. Frederickson alluded to something before that I'd like to get your own experiences on. Not just those suits where where politics has influenced the judge, but what have you experienced in terms of people you've had to turn away when they've come to you as lawyers? You being the lawyer saying, look, the judiciary is stacked against you, you won't get a favorable ruling, be it in civil rights, be it in law, be it in labor, being in everything else.
Well, I'm turned to anyone who has an example. I think we're mostly advocates in the policy arena, so I'm not sure we have those kinds of personal experiences. But I certainly, it's clear, and I could tell you an experience that I've had where I've been meeting with lawyers in states that have very competitive state judicial elections, and they will tell me that a judge or a candidate comes to them and wants to do a fundraiser, perhaps at their firm, and they have to go. And so, the consequences are that they tend to have to host everyone who wants to be hosted and give to everybody who wants to give. And if not, that's, they know that anyone who gets elected is going to know that they or their firm decided not to contribute or not to host the event. And so I think tends to play out more in that way, in that you can talk to a lot of lawyers in these communities who would be very happy, I think, for the system to just go away because they are really blackmailed in many ways. And I don't think the judges like it terribly much either. And you can see some of them have been on the record as talking about that they feel kind of like, a streetwalker or something, somebody who's selling themselves for cash, and it does a great disservice to all of our vision of justice. But I think you tend to see it more in those circumstances. By the time someone is coming, to ask for a lawyer, usually the lawyer already knows where the bread is buttered, and they've made sure that the bread has been buttered, or they're in a different profession altogether. Is that over here?
Skip Kaltenhauser. I'm a writer. Sorry, Skip Kaltenhauser. I was wondering if you anticipate doing any individual analysis of particular sectors of the business community, such as the finance sector versus individuals, and what the results are.
We're at ACS. We're definitely considering new avenues for empirical research. We have not yet made any final decisions, but we are definitely considering those areas that you've mentioned. I think that over here. Yes.
I'm Jeff Stinson. I'm a reporter with stateline.org. That's the news service of the Pew Charitable Trusts, and we write about state issues. And I have a question for Alicia and Bert especially. It's about the direct solicitation of campaign funds by judicial candidates, especially in light of the Williams-Yulee versus Florida Bar case at the Supreme Court. We'll hear arguments on it in about a week.
Alicia, why don't you start?
Sure. So for those who might not be familiar with it, Williams-Yulee is a challenge to a code of conduct in Florida, which bars judges from personally soliciting campaign contributions. So 39 states use judicial elections in one form or another to elect judges. All of them have some codes of conduct that limit how judges can engage in their campaigns. And 30 of those states have specifically codes of conduct that limit personal solicitation of contributions. So the way it works is that a judge can still fundraise, but what they have to do is create a separate campaign committee that fundraises on their behalf. So you can't call someone up on the phone and directly ask them for funding. In many states, you can't sign your name even to a letter requesting funding. And the question before the Supreme Court now is whether or not these kinds of what I would say are very reasonable regulations of judicial conduct are barred by the First Amendment. And so, we'll be seeing the oral argument is scheduled for January 20th. So, I think we'll be seeing very soon, at least a preliminary sense of where the court's thinking might be about this case. I think the thing that's important to be aware of when, looking at the issues in this case is that, this isn't a traditional kind of campaign finance case. Because this is a case about judicial elections, there's a separate constitutional interest at stake, which is a due process concern, which is a concern about the integrity of our courts and public confidence in our courts. So when you're looking at, what are the compelling interests at stake here, what are the reasons for regulating this kind of conduct, this kind of campaign conduct, there's a constitutionally based concern that isn't at issue in some of the other kinds of regulations that the Supreme Court has struck down, which is based in the fact that courts are constitutionally required to be fair and impartial, and integral to that as well is public confidence that courts are fair and impartial. And these kinds of regulations of direct solicitation, I would say, are very directly developed to respond to that compelling interest in judicial integrity.
I would just add to that, piggybacking right off Alicia's last point, that in fact, Justice has taken the Brennan Center commissioned a poll that asked the public this very question about their confidence in the courts. And in fact, 63% of respondents, I believe it was last month, said that they would have less confidence in the courts if they knew the judges could personally raise money. And I think the other significance of the case is that it is this window into what's going on. Judicial elections are broken. Whether it's this case, whether it's a legislative battle in this state or that state or whatever, you're hearing today why this has to become part of the agenda of everybody who cares about democracy issues. Democracy reform is no longer a two-branch issue. It's a three-branch issue.
And I would just add that there was a group of some of the empirical scholars that we worked with that filed an amicus brief in the case to basically show that this can't be dealt with as an abstract, simple appearance of corruption issue, that the data shows, as I mentioned, that direct contributions to sitting justices actually change their votes. It's a real corruption issue, not a perceived corruption issue. So I think we have time for one more question. So,
I'll keep it quick. My name's Michael Beckel. I'm a reporter at the Center for Public Integrity here in Washington, D.C., and we've talked about the issue of down ballot races. A lot of these races are further down on the ballot, and the less attention getting presidential, Senate, governor's races. Has there been any research into the effect of the independent spending on voter turnout in judicial elections?
Brennan or
I don't know of any empirical research on. I've said I don't know of any empirical research on that question. I mean, generally. Generally, voter turnout is, a lot lower for judicial elections than it is for other elections. Both when they're occurring at different points, you have lower turnout for judicial elections, and as well, even when judges are on the ballot, there's a fall off as people are voting for judicial elections. I think generally, if an election becomes more politicized, which might occur when you have a flood of attack ads or something like that, that would I would expect that might increase attention to that race and might, reduce the amount of fall off that you're seeing of lower ballot on lower ballot races. But I don't know of any studies about it.
I think this gets back to perhaps one last item in the solution set here, which is if you live in a state where judges are currently elected, in addition to hopefully helping reform the system, vote in these elections. Turnout is incredibly low. I live up the street from Carolyn in Montgomery County. I have these same problems. I do this for a living. I have a problem voting in judicial elections because of the amount of information that's not there. We've done focus groups with voters who are good voters. They turn out all the time. They do president, Senate, city council. They get to the judges and they stop. And we ask them why, and they say, we just need more information. It's weird to vote for a judge in the first place, and we don't have information. And, it's not easy yet, but if everybody can make the effort to vote in a judicial election, you're less likely to have it perceived as a vacuum for a special interest to spend a few dollars, turn out its base, and try to tip a race.
Well, so can we all give a round of applause for this fabulous panel?